There are moments in life that split everything into before and after. Before you knew, after you couldn't unknow. I've been a journalist for 19 years. I've covered wars. I've stood in rooms where presidents cried. I've watched governments fall. But nothing prepared me for the morning I stood outside the Eastern Service entrance of Windsor Castle and watched a Royal Guard hand a sealed legal envelope to a woman in a gray suit while the Union Jack was still being lowered in mourning. That was the moment I understood something I should have understood a long time ago. The palace is not a fairy tale. It never was. Let me take you back to the beginning. Not the beginning of the lawsuit, the beginning of the day that made the lawsuit inevitable. It was a Tuesday in late October. The kind of Tuesday that England does particularly well, overcast without committing to rain, cold without being cruel, the sky the color of old pewter pressed flat against the Thames. Windsor itself had that particular stillness it gets in the off-season, when the tourist coaches thin out and the town goes back to being just a town, rather than a monument to something larger than itself. I'd driven down from London the night before. My editor had rung me at 10:30 in the evening with that tone she uses, measured, quiet, which means run, don't walk. She said there were rumblings. She said people inside the palace were talking. She said nothing specific because she never does on the phone, but I'd worked with her long enough to know that when she rings me at 10:30 on a Monday, she isn't ringing about nothing. So I drove down, parked near the Long Walk, found a bed and breakfast that still had a room because the owner hadn't bothered updating her online calendar since June. And I spent the night reading through everything I'd accumulated over the previous 3 weeks about the quiet, barely reported tensions building inside the royal household. By 7 the next morning, I was standing in a coffee shop on Peascod Street with a paper cup going cold in my hand, watching the castle through the window like it owed me an explanation. The town was quiet in the way Windsor is quiet on gray autumn mornings. A few shopkeepers pulling up shutters, a man walking a whippet along the pavement, 2 tourists, German, I think, based on their jackets and the camera one of them carried, standing at the bottom of the hill taking photographs of the round tower. The castle above all of it, massive and indifferent, the way very old things are indifferent. It had outlasted empires. It wasn't going to trouble itself about a journalist and a cold cup of coffee. The guards were already at their posts. That's something people don't fully appreciate when they think about the Royal Guard. They think about the bearskin hats and the red tunics and the standing perfectly still while tourists make faces. They think of it as a performance. A piece of living theater put on for the benefit of visitors and Instagram accounts. They're wrong. The Guard is a function. It is an institution older than most of the nations that send those tourists to gawp at it, and the men and women who serve in it are not performing anything. They are working. They are protecting. And some of them, the ones who have done it long enough, carry something in their faces that isn't quite pride and isn't quite grief, but is somewhere between the two. I noticed one of them that morning. I noticed him because he was standing at his post near the Henry VIII gate, not the main entrance tourists use, but the older one to the south, and he was completely still in a way that seemed different from the stillness of the other guards. It's hard to explain. There's still because you are trained to be still, and then there's still because something inside you has gone very quiet and very cold. He had the second kind. I noted him without really knowing why. Filed him away in the back of my mind the way you do with things that don't yet make sense. Then my phone rang. It was my source inside the household. She doesn't have a name in this story because she can't. She works in an administrative capacity that puts her in proximity to decisions and schedules and conversations that were never meant to travel as far as my recorder. She rang me at 7:14 and said 4 words that changed everything about my morning. "It's happening today, Marcus." Marcus is not my name. It's what she calls me when she needs to be careful. I don't know whose name it is. I've never asked. I said, "What's happening today?" She said, "The announcement, the official one. They've been preparing the language since Friday." I stepped out of the coffee shop into the cold air. The German tourists had moved closer to the gate. The man with the whippet had disappeared around a corner. The guard at the Henry VIII gate was still standing exactly as he'd been standing when I first looked at him. I said, "Are you certain?" She said, "The Lord Chamberlain's office drafted the statement. It went a final review last night. There's a press pool being assembled. And Marcus, there's something else. Something that doesn't make sense yet, but you need to know. I waited. She said, one of the household division men. He's been speaking to a solicitor. Not a personal solicitor, an employment and civil rights solicitor, the kind that takes cases they intend to win. The air felt different after that, colder or maybe just more honest about how cold it already was. I said, which guard? She gave me a name. I won't write it here yet because names matter, and this one matters in a particular way that deserves its own moment. But I will say this. The name was attached to a man I had seen before, in a different context, in a photograph that had circulated briefly in the press 6 months earlier and then been quietly buried. I put the phone in my pocket and looked back through the coffee shop window at the empty table where I'd been sitting. Then I looked up at the guard at the Henry VIII gate, and I understood why his stillness had seemed different. Build tension. The announcement came at 11:17 in the morning. Not from the palace gates, not from a herald in ceremonial dress, not with any of the pomp that a moment of that magnitude might theoretically deserve. It came via an email. The Royal Communications Office sent a press statement to accredited journalists at 11:17, and within 4 minutes it was on every major news wire and news site in the English-speaking world, and within 7 minutes it was everywhere else. The statement was 63 words long. I counted them. I still remember them, not word for word, but in their shape and weight. They said that His Majesty King Charles III, having given long and careful consideration to the welfare of the nation and the future of the institution he served, was announcing his intention to formally abdicate the throne in favor of His Royal Highness William, Prince of Wales. 63 words. The end of a reign. I was standing in a car park on the south side of Windsor town when I read them on my phone. Around me, people were doing the same. I watched it happen in real time, the way the information moved through a crowd before the crowd even knew the information was coming. A woman in a green coat looked at her phone and went completely still. A teenage boy scrolled and then scrolled back and then looked at the boy standing next to him with his mouth slightly open. A man near the car park entrance said something I couldn't hear, but his companion grabbed his arm. Inside Windsor Castle, inside all the official residences, inside the offices and the kitchens and the guard rooms and the long carpeted corridors, I can only imagine what those 63 words did. Actually, I don't have to imagine entirely, because I had sources, and they rang. The first call came at 11:22 from a woman who works in the press office, junior, cautious, but present in a lot of rooms. She said it was, and I'm paraphrasing because I didn't have my recorder on, she said it was as though someone had turned off all the sound. The announcement happened and the room went absolutely silent, not the silence of people being respectful. The silence of people being genuinely, totally stunned. Even the people who had known or suspected seemed to find that the actual reality of it was different from the theoretical understanding of it. The second call was from my primary source. She sounded different from the morning, tighter. She said, "It's today. He's already filed." I said, "The guard." She said, "Within the hour. His solicitor submitted to the High Court this morning. They were waiting for the announcement. They needed it on record first, officially, before the filing made sense. Do you understand what I'm telling you?" I understood. The lawsuit had been timed, not as an act of opportunism, as a legal strategy. By filing immediately after the abdication announcement, the guard and his solicitor had ensured that the complaint would be processed in a specific constitutional context, one in which Charles was transitioning from sovereign to private citizen, and in which certain legal immunities that attached to the crown were potentially in flux. It was, whatever else you might say about it, a very precise piece of legal thinking. I said, "What is the basis of the complaint?" She said, "Constructive dismissal, discrimination, and something under employment law that I don't fully understand but the solicitor describes as systemic breach of duty of care." I said, "Against whom?" She paused. She said, "The Duchess of Cornwall, Camilla. I've been a journalist for 19 years. I've heard a lot of things that surprised me. I've covered a lot of stories that seemed impossible until they weren't. But sitting in that car park in Windsor on that particular Tuesday morning, I felt something that I can only describe as the ground shifting slightly. Not literally, emotionally. The way the world rearranges itself when a piece of information arrives that doesn't fit into any of the frameworks you had prepared for it. I said, "Are you certain?" She said, "His name is Corporal James Whitmore. He served in the household division for 11 years. He was assigned to the Queen's household, Camilla's household, after the accession, 14 months ago. And he is alleging that in those 14 months, his career was systematically undermined. His requests for transfer were denied without explanation, and he was subjected to conduct by senior household staff acting on behalf of the Duchess that constitutes constructive dismissal under UK employment law." She stopped. Then she said, "And Marcus, he says he has documentation, emails, a recording, a witness." I sat in my car and stared through the windshield at the gray English sky. Corporal James Whitmore. I pulled out my notebook and wrote the name down. Climax Part 1. By 2 in the afternoon, I had made 17 phone calls, sent 11 emails, and consumed 3 cups of coffee that had all gone cold before I drank them. What I had assembled, through fragments and partial confirmations, and one extraordinarily useful conversation with a retired legal clerk who had a cousin who worked in civil employment filings, was this. Corporal James Whitmore, aged 34, had served in the Household Division, the collective name for the regiment of guards responsible for protecting the royal family and performing ceremonial duties, since the age of 23. His record was, by every account I could find or hear, exemplary. Commendations in 2019. A role in the security detail during a state visit in 2021 that his superiors had specifically requested him for. A reputation among colleagues as steady, professional, and not given to drama. 14 months ago, he had been assigned to duties that placed him within the operational sphere of Camilla's household. Not her personal protection, that was a different function handled by the Royal Protection Command, which is part of the Metropolitan Police, not the Household Division. Rather, Whitmore's role was ceremonial and perimeter adjacent. He was part of the formal guard presence at official engagements, at household events, at certain functions where the physical presence of uniformed guards was protocol. What changed in those 14 months is what the lawsuit is about. What I was able to establish from sources, not from the lawsuit itself, which was not yet publicly available in its full form, was a pattern that, once you saw it, you couldn't unsee. The first incident, according to what my primary source relayed, occurred about 6 weeks into Whitmore's assignment. He had been present at a private household function. During the preparation for that function, he had witnessed something. His sources, as relayed to me, did not specify precisely what, but he had apparently made a formal internal report, standard procedure. The kind of report that guardsmen are required to file when they observe anything that might constitute a security or protocol concern. The report disappeared. Not literally, not in the dramatic sense. It was received, logged, and then nothing, no follow-up, no acknowledgement. When Whitmore inquired about it, he was told by a senior household administrator that the matter had been reviewed and found to require no further action. He accepted this. The second incident was different. It involved not a report but a request, a formal request for transfer, submitted through proper channels, citing what Whitmore described in the request as personal reasons affecting operational effectiveness. This is the language soldiers use when they want to communicate distress without having to explain it. Anyone in the military or in the institutional culture around it would recognize the phrase for what it is. The request was denied. No reason given, no timeline offered for reconsideration. The third incident is the one that the lawsuit, as I understood it at the time, identified as the critical breach. It involved a direct interaction, not between Whitmore and Camilla personally, but between Whitmore and a senior member of Camilla's personal household staff. A woman in a position of considerable administrative authority within the household. This woman had, according to Whitmore's account, approached him in a way that he later described to his solicitor as deliberately intimidating. She had made clear, not through explicit language, but through implication and through the exercise of institutional power, that his continued career prospects within the household division were connected to his willingness to remain in his current posting without complaint. That is not a direct threat, but it is something. Under UK employment law, it is potentially quite a significant something. Whitmore had, at this point, consulted a solicitor, not because he was certain he had a case, but because he was certain that what was happening to him was wrong, and he didn't know any other way to name it. What the solicitor found, when Whitmore showed her the documentation he'd quietly kept, the logged report and its non-response, the denied transfer request, a series of emails between household administrators that Whitmore had been inadvertently copied on, and which revealed a degree of coordinated commentary on his suitability for the role. What the solicitor found was the outline of a case. The recording I had heard about was made on Whitmore's personal phone during a conversation he had not anticipated becoming significant. His solicitor would later argue that its admissibility was sound under the circumstances. It captured the household administrator's conversation with him in enough detail to establish, with reasonable clarity, what had been said and what had been implied. I didn't hear the recording that day, but I was told what was on it. And sitting in my car in Windsor, I understood why the solicitor had waited for the abdication announcement. Because what the recording contained, what the lawsuit was built around, was not simply a case of workplace bullying or institutional misdirection. It was a case that, if substantiated, pointed upward, past the administrator, past the household staff, upward in the direction that lawsuits are rarely brave enough to point. Resolution Part 1. By evening, Windsor had changed. The tourist coaches that had been absent in the morning had returned, not for Windsor specifically, but because the news had sent people into the streets in the way that news of this magnitude sometimes does. People want to be somewhere. They want to stand near something large and historic and feel the weight of the moment in a physical space rather than through a screen. I stood on the long walk as the light failed and watched the castle glow against the darkening sky and tried to organize everything I knew into something coherent. Corporal James Whitmore had filed a lawsuit against Camilla. He had filed it on the day of the abdication announcement. On the day the man who had placed Camilla at the center of the royal household, the man whose marriage to her had elevated her to a position of extraordinary institutional power, had announced he was stepping away from the crown. The timing was not accidental. The timing was, in its quiet way, one of the most deliberate things I had encountered in 19 years of covering the people who operate in the proximity of power. Because here is what I understood, standing there on the long walk with the cold coming in off the park and the castle lights steady above the trees. The lawsuit wasn't just about Corporal James Whitmore. It was about what happens when an institution decides that its need to protect itself is more important than its duty to the people inside it. It was about the gap between the image, the ceremony, the bearskins, the standing perfectly still while the world watches, and the reality that the standing still is sometimes not a choice at all. It was about a man who had served for 11 years with distinction, who had done everything right, who had followed every rule, and who had found that the rules did not apply equally in every direction. And it was, perhaps most of all, about a moment when the architecture of power shifted just enough, just fractionally enough, that a door opened that had previously been sealed. And James Whitmore, Corporal, Household Division, walked through it. That evening his solicitor's office issued a short statement, 3 sentences. It confirmed the filing. It stated that Corporal Whitmore's legal team was confident in the merits of the claim. And it said, and I read this line 4 times standing on the long walk, that Corporal Whitmore had not taken this step lightly, and that he had done so not for personal gain, but because he believed that what had happened to him should not happen to anyone else. Not for personal gain, because he believed it should not happen to anyone else. I put my phone in my pocket. Above me, the flag above Windsor Castle, which had been at half-mast all day, in mourning for the rain that was ending, shifted slightly in the evening wind. I watched it for a long moment. Then I walked back toward my car to write the first part of this story. Hook. Before this becomes a story about a lawsuit, I want to tell you about the man. Because lawsuits are documents. They are filings and schedules and legal arguments constructed in careful language designed to withstand scrutiny. They are important, but they are not the story. They are the container the story is poured into when there is nowhere else for it to go. The story is James Whitmore. And the story of James Whitmore begins, as most important stories do, long before anything dramatic happened. Set up. I found him indirectly through a series of conversations that I will not fully detail here on the second day after the announcement. Not in person, not yet, but through the people who knew him. A retired sergeant who had served alongside him in the early years. A woman who had been in his ceremonial cohort for 2 deployments. A man who had trained with him at Pirbright when they were both 23 and impossibly young, and certain that they had made the right decision. They all said the same thing about him, in different words and with different expressions on their faces. He was the kind of man who showed up. That sounds simple. It's not simple. In any institution, military, civilian, royal, corporate, the people who genuinely, reliably, consistently show up are rarer than anyone in charge will ever publicly acknowledge. They are the architecture the institution is actually built on, rather than the architecture it claims to be built on. Whitmore had been that. The retired sergeant told me, we spoke by phone, and he asked me not to name him, which I won't, that in 8 years of service he had never once seen Whitmore put himself ahead of his duty. Not in the showy way some guardsmen do, performing dedication for an audience. In the actual, functional, unremarkable way that genuine professionalism presents itself. Whitmore was simply there. He did the job. He did it better than most. He didn't complain, or rather, and this distinction matters, he didn't complain to the wrong people. He told me one specific story. He was hesitant to tell it. He said he wasn't sure it was relevant. I said, let me decide that. He said that there had been an incident, years before the Whitmore posting became famous, during a public engagement. Not at Windsor. At another location that he would not specify. During a long ceremonial event, a guardsman in Whitmore's immediate unit had collapsed. Heat, dehydration, a combination of factors that come together on warm days when you're standing at attention in full kit for hours. Protocol is clear in this situation. You do not break form until the relief is organized, and the relief in this case was slow. Everyone in that unit was watching the collapsed guardsman. Watching and not moving, because that's the protocol. Whitmore moved. Not dramatically. Not in a way that disrupted the ceremony or drew attention to anything he didn't intend to draw attention to. He shifted by a matter of inches, in a way that positioned himself between the fallen guardsman and a camera angle that would have captured the scene badly. He didn't leave his post. He didn't break the ceremony. But he did, with 3 inches of movement, give his colleague a kind of dignity while the relief came. The retired sergeant told me he had never forgotten it. I'm telling you this because you need to understand who James Whitmore was before you understand what was done to him. He grew up in Wolverhampton, second son of a man who drove lorries and a woman who worked in school administration. He joined the army at 23, older than many of his cohort, because he had spent 2 years after school trying other things and finding them insufficient. He was precise about language. His colleagues noted this. In an institution built on precision, the people who are genuinely precise, rather than performing precision, stand out. He was, by the time of his assignment to the royal household, 33 years old. He had served in Germany and in Belize in addition to his ceremonial UK postings. He had a flat in South London that he rented. He had a sister in Shropshire and a mother who still lived in Wolverhampton. He played chess online in the evenings and read history, particularly military history, and had a preference for accounts that focused on the experience of ordinary soldiers rather than generals. He was not, by any measure anyone applied, a troublemaker. He was not political. He was not ambitious in the way that creates enemies. He was a man doing a job, doing it extremely well, and asking nothing from the institution except that it treat him according to the rules it had asked him to operate by. The rules did not hold. Build tension. The woman who had served in his ceremonial cohort agreed to speak to me at a cafe in Battersea. She was careful. She arrived 10 minutes early and sat where she could see the door and didn't use my name when she spoke to me, even though she'd agreed to the meeting. Old habits, or new ones formed out of an awareness that this story was becoming visible in ways that made people cautious. She told me that Whitmore had spoken to her toward the end of his final months in the posting on one occasion. Just once. She emphasized this, just once, because he was not the kind of man who sought sympathy, and he would not have said anything at all except that she had asked him directly if he was all right. He had told her, "No, I'm not, but I don't know how to explain it without sounding like I've lost my mind." She'd said, "Try." And he'd said, "It's like there are 2 sets of rules, and I'm only allowed to follow one of them, but the one I'm allowed to follow isn't the one that protects me." She set her coffee cup down and looked at the table. She said to me, "I've thought about those words every day since, every single day. I asked her if she thought he had been targeted specifically. She was quiet for a long time. Then she said, "I think he saw something he wasn't supposed to see. And I think the problem wasn't what he did with what he saw. The problem was that he existed in a space where he could see it." She wouldn't say more than that. She finished her coffee and left. I sat at the table for a while after she went and tried to map what I knew onto what she had suggested. The internal report that had vanished, filed after an incident at a private household function, an incident that had never been specified to me in detail. The request for transfer, denied without explanation. The conversation with the senior administrator, the one that had been recorded, the one that spoke of career prospects and postings in the same breath. And underneath all of it, the question of what James Whitmore had seen. I reached out to his solicitor's office 3 times over the following 2 days. The responses were polite and the same. The matter was sub judice and her client was not available for comment. This was correct procedure and I didn't push it. But on the second response, there was a single additional sentence that had not been in the first. It said, "Our client's position will be made fully clear through the legal process, and we are confident that the documentation will speak for itself." Documentation will speak for itself. Not the testimony, not the witnesses, the documentation. I kept coming back to that word, documentation, because in the context of the royal household, documentation is not simply evidence. It is, in a very specific institutional sense, everything. The household runs on protocol and record, every engagement logged, every communication filed, every decision, at least the ones that are meant to be visible, accounted for. Which means that documentation, in this context, could be one of 2 things. Either Whitmore had captured something that the household had failed to destroy, or the household had documentation that it didn't realize Whitmore possessed. I suspected it was both. On the 3rd day after the announcement, I managed to speak briefly with a retired legal scholar who had written extensively on Crown immunity and employment law, and who had, until his retirement, been considered one of the foremost authorities on the intersection of constitutional law and personal civil rights in the UK. I asked him, in general terms and without naming names, about the constitutional implications of filing a civil claim against a member of the royal household at a moment when the sovereign was in the process of abdicating. He was quiet for a moment. Then he said, "It's extraordinarily precise timing. If I were advising the claimant's legal team, that timing is exactly what I would recommend. The abdication creates a moment of constitutional fluidity. Certain protections that attach to the Crown as an institution, particularly around the employment relationships of those who serve the sovereign directly, are in a period of definitional uncertainty during a transition. The argument would be that the claimant is not targeting a sitting sovereign or the institution of the Crown per se, but rather an individual whose formal institutional role is itself in the process of being redefined." I said, "Is that argument strong?" He said, "It is not weak. Whether it is strong depends on documentation." That word again. I thanked him and ended the call and sat for a long time thinking about James Whitmore in his flat in South London, playing chess online and reading about ordinary soldiers and carrying, in whatever secure physical or digital space he had chosen, the documentation that his solicitor believed would speak for itself. Climax Part 2. The story broke properly on the 4th day. Not through my publication first, through a legal correspondent at a national newspaper who had a source inside the High Court filing registry. They ran a brief piece, careful and legally hedged, that confirmed a civil claim had been filed by a named member of the Household Division against the household of the Queen Consort. It named Whitmore. It named Camilla. It used the language of employment law: constructive dismissal, duty of care, systematic institutional failure. Within 2 hours, it was everywhere. I watched it happen from a different cafe in a different part of London, where I was sitting with a second coffee going cold and my notebook open, and the particular feeling that comes when a story you've been carrying privately suddenly becomes public and changes shape in the light. The reaction was immediate and predictable in some ways. Legal commentators appeared on every news program to assess the likelihood of the claim succeeding. Royal commentators appeared to reassure their audiences that the palace was robust and the institution resilient. Social media, as social media does, immediately sorted itself into furious camps with no middle ground. But the reactions that interested me were the quieter ones. A former senior civil servant who had worked adjacent to royal affairs for 20 years wrote a short post on a professional networking platform that said simply, "It is not surprising. The surprising thing is that it took this long." He deleted it within an hour. I had already copied it. A barrister who had worked on royal household employment matters in the past, I won't say when or for which party, called me, which I had not expected, and said, "You should know that this is not the first time something of this nature has been close to happening. It is the first time someone saw it through." She wouldn't say more. And my primary source, who rang me at 7:30 that evening, said something that I've been turning over in my mind since. She said, "You know what the most remarkable thing is, Marcus? He didn't leak it. He didn't go to the press. He didn't talk. He went through the legal process. He did everything right, the way he always does everything right. He just did it outside the building instead of inside it." I said, "Do you think it'll succeed?" She was quiet for a moment. Then she said, "I think the documentation will speak for itself." Third time I'd heard that phrase. I started to understand what it meant. Later that evening, a friend who worked in television production rang me, not about the story, just to catch up, because we hadn't spoken in weeks. And I found myself, for the first time since Tuesday morning, talking about the story not as a journalist but as a person who had been sitting with it for 4 days. I told him about Whitmore, about the 2 sets of rules, about the 3 inches of movement that had given a collapsed colleague dignity while everyone else stood still, about the chess and the military history books and the flat in South London, about the 11 years of exemplary service and the 14 months that had unwound something that took 11 years to build. My friend listened without interrupting, which is unusual for him. When I finished, he said, "It sounds like a story about someone who believed the institution was what it said it was." I said, "Yes." He said, "And then found out what it actually was." I said, "Yes." He said, "That's the oldest story there is." Resolution Part 2. By the end of that first week, the legal situation had settled into the particular kind of limbo that civil cases occupy in their early stages, acknowledged, filed, legally live, but nowhere near resolution. There would be hearings. There would be responses from the other side. There would be months, potentially years, of process before anything definitive was known. The palace, and I use the word to mean the institutional communications apparatus rather than any specific building, issued no statement directly addressing the lawsuit. They issued a broader statement about the ongoing transition of the household in the context of the abdication, which was both entirely appropriate in itself, and which functioned deliberately as a context that made specific comment on the legal matter impossible without appearing to interfere with due process. It was, as these things often are, a very precise non-answer. Whitmore remained silent. His solicitor remained precise. And the household documentation that formed the center of the case remained, for the moment, sealed and pending and waiting. I went back to Windsor on the Friday. I'm not entirely sure why. There wasn't anything specific to find there. The town was quieter again. The immediate surge of post-announcement visitors had subsided. The castle was simply the castle. The guards were at their posts. I stood at the Henry VIII gate for a while. The same gate where I had first noticed the quality of stillness on Tuesday morning, without understanding what I was seeing. There was a different guard at the post now. Younger, I thought, the particular expression that comes with early service rather than long service. He stood with the trained stillness of someone who has learned the technique rather than arrived at it. I thought about Whitmore, about standing at a post in ceremony for 11 years, about knowing, precisely and professionally, how to be still, and about what it costs, what it actually costs in the part of yourself that has nothing to do with training to finally decide to move. Hook, here is what I know now that I didn't know on Tuesday morning in the car park in Windsor. The document at the center of the case is not an accusation. It is a record. There is a difference. An accusation is a claim. A record is a thing that happened, written down with a date and a time and the initials of whoever logged it. Records are harder than accusations. Records don't require someone to believe anything. They only require someone to read. What James Whitmore had what his solicitor had described, in 3 responses to my 3 inquiries, as documentation that would speak for itself, was a record. And what it recorded is what this final part of the story is about. Set up. 3 weeks after the abdication announcement, I received a document in the post. Unmarked envelope, London postmark, no return address. Inside was a single sheet of paper, a photocopy, not an original, and on it was printed a chain of internal communications. I won't reproduce it verbatim. I can't, for reasons that include both legal caution and the protection of sources I am still not certain I fully understand. But I can tell you what it contained in substance. It was an email chain between 3 people within the royal household administrative staff. The names I cannot publish. The roles I can describe in general terms. One was in household operations, one was in what might loosely be called staff liaison, and one was in a more senior position that I will describe only as executive administration. The chain concerned Corporal James Whitmore directly. The earliest email in the chain was sent 14 months ago, shortly after Whitmore's assignment to the household. It was, on the surface, a routine communication about staffing. It mentioned Whitmore by name and by rank. It said that his assignment had been flagged, that word flagged, by a senior figure. It said that his previous internal report, the one he had filed after the first incident, the one that had disappeared without follow-up, had created what the email writer called a need for careful handling. Need for careful handling. The second email was a response. It was practical. It discussed Whitmore's transfer request, the one that had been denied without explanation. The writer of the second email noted that the denial had been processed, but expressed some institutional discomfort with the absence of a stated reason. They suggested that a legitimate professional reason be constructed, not their language, but the implication was clear to formalize the denial. This would, the email noted, make the record tidier in the event of any future review. In the event of any future review. The third email was from the most senior of the 3. It was the shortest. It said only, handle this at your level. I don't need to be visible in this. I don't need to be visible in this. I sat at my kitchen table with that photocopy for a long time. I want to be careful here. I cannot independently verify the document's authenticity. I cannot know with certainty whether it was sent to me by someone connected to Whitmore's legal team, by someone inside the household who had their own reasons for wanting this information to circulate, or by some other party entirely whose interest in the story I couldn't identify. Legal cases are complicated ecosystems. People send things for reasons that are not always the reasons they present. But the document was consistent with everything I had learned from every other source over the preceding 3 weeks. And it used the phrase careful handling in a context that mapped precisely onto what the woman from Whitmore's cohort had described when she said, "I think he saw something he wasn't supposed to see. And the problem was that he existed in a space where he could see it." Build tension. I spent the following days trying to understand what Whitmore had originally reported. The first internal report, filed 6 weeks into his posting, the one that had been received, logged, and then handled into nothing. I had 4 sources who knew something about it. None of them would tell me directly what it contained. But through the particular language of people who are being careful, through the things they said around the thing they weren't saying, I was able to build an outline. What Whitmore had seen was not a crime. I want to be clear about that. Nothing I gathered from any source at any point suggested that what he had witnessed and reported was criminal in nature. It was not a matter for the police. It was not violence or fraud or anything in that territory. What it was, I believe, based on the accumulated impression left by every cautious, partial, carefully worded account I received, was an exercise of power that was inconsistent with the public presentation of the household and the people within it. That is deliberately vague. I'm being deliberately vague because I am not certain, and because in this territory, the distance between what I believe and what I can evidence is the distance between responsible journalism and recklessness. What I can say with more confidence is this. James Whitmore had witnessed something, reported it through official channels, been told it required no further action, and had then become, not immediately, but over the following months, gradually, procedurally, bureaucratically, a problem to be managed. Not because he had done anything wrong, but because he had done everything right. He had filed the report he was supposed to file. He had requested a transfer through the correct procedure. He had said nothing to the press, nothing to colleagues beyond one honest conversation with a friend who asked directly. He had kept the documentation he was entitled to keep. He had, when the situation became untenable, sought legal advice. He had, in every possible way, operated exactly within the rules. And the rules, as the email chain suggested, had been bent quietly around him to make sure that operating within the rules didn't help him. There is a concept in employment law called constructive dismissal that is, in its legal form, quite specific and technical. But in its human form, in the experience of the person it happens to, it is simpler and more brutal. It means we will not fire you. We will make the situation so untenable that you feel you have no choice but to leave. And then when you leave, we will say you left voluntarily. What Whitmore's solicitor had apparently constructed, from the transfer denial, the email chain, the recorded conversation with the household administrator, and whatever additional materials had not yet been made public, was an argument that this is precisely what had been done to him. Not with dramatic intensity, not with anyone shouting or threatening overtly, with the quiet, institutional, almost polite suffocation that is the particular expertise of organizations that have been managing inconvenient people for centuries. I thought about this a great deal in the weeks after the filing. I thought about the 63 words of the abdication announcement, and the 3 sentences of the solicitor's statement, and the 3 words of the most senior administrator's email. I don't need to be visible in this, and how much of the actual story of power exists in the space between official statements. I thought about James Whitmore, aged 23, arriving at Pirbright Barracks, certain that he had made the right decision. Believing, as most people who join institutions built on honor and discipline believe, that the institution would be worthy of him if he was worthy of it. And I thought about him at 34, in a solicitor's office, handing over a folder of documentation and a phone recording and a denied transfer form, having finally understood what it had cost him to keep believing that. Climax Part 3. The hearing was not public. First hearings in civil employment cases rarely are, and this one carried enough constitutional sensitivity that the court had indicated it would proceed cautiously with disclosure. What I know about it comes from a single source, not my primary source, who was not present, but a different one, closer to the legal process, whose connection to the case I will not specify further. The hearing was brief, procedural, the kind of hearing that matters enormously in legal terms and would appear unremarkable to anyone watching without context. Whitmore was present. My source told me that he was dressed in civilian clothes, that he sat with his solicitor, that he was, in my source's words, completely composed in a way that was either admirable or heartbreaking, probably both. The other side's legal team was present. They were, as one might expect, from a firm of considerable reputation and substantial resource. They were polite. They were precise. They contested several procedural points. The judge, whose name I'm not including because it is irrelevant to the human story, asked a series of questions about the documentation. About its provenance, its completeness, its chain of custody. Standard questions. But the way my source described the judge's manner when he asked about the email chain specifically, the particular quality of attention the judge gave to that part of the submission, suggested that what was in that chain had registered with the weight that Whitmore's solicitor had always believed it carried. After the hearing, Whitmore walked out of the court building into the dull London afternoon. My source was watching from across the street, not intrusively, just present. Whitmore stood on the pavement for a moment. He looked up at the sky, gray, typically gray, the specific gray of London that doesn't commit to anything. Then he looked at his phone. Then he put the phone in his pocket. Then he walked away. Not quickly, not with any particular expression that my source could read from that distance. He just walked, like a man who had done something he intended to do and was now going to wherever he was going next. My source said he looked like someone who had finished something, not won it, finished it. That's an important distinction. I spoke to the retired sergeant again, 2 days after the hearing. He'd seen the coverage. He was quiet about it in the way men of his generation tend to be quiet about things that they feel strongly about. The quietness of people who have learned that strong feeling doesn't always help, and composure is sometimes more honest than expression. He said, I always thought if Jimmy ever had a real problem, he'd handle it properly. I never thought it would come to this. I thought the institution would, I don't know, see him. He stopped. They never saw him, that's the thing. 11 years and they never really saw him. I said, do you think the case will succeed? He said, I think that's the wrong question. The right question is whether this is the kind of story that ends or the kind that continues. I said, what's the difference? He said, stories that end have a clear guilty party and a clear verdict and everyone goes home and draws a line. Stories that continue change the way things work slowly, without any single moment you can point to. He's not a crusader. He's not trying to bring anything down. He just wants what happened to him acknowledged. And the interesting thing about acknowledgement is that once something's acknowledged, it can't be unacknowledged. I wrote that down. I wrote all of it down. Resolution. The case is ongoing. I cannot tell you how it ends because it hasn't ended. I cannot tell you what the documentation will ultimately prove because the legal process is not finished with it. I cannot tell you whether Corporal James Whitmore will be vindicated by the system he chose to engage rather than abandon. What I can tell you is what I know. I know that James Whitmore served for 11 years with distinction and was undone not by anything he did wrong, but by the act of doing things right. I know that the timing of his legal filing was not accidental, that it was precise and deliberate, and that the precision and deliberation were, in their way, a portrait of the man himself. I know that 3 words in an email, I don't need to be visible in this, constitute a kind of institutional confession that the writer never imagined would become evidence. I know that somewhere in South London, on evenings when he is not otherwise engaged, James Whitmore plays chess online and reads about ordinary soldiers and waits for a legal process to reach whatever conclusion it reaches. And I know that the retired sergeant was right when he said the question is not whether the case succeeds, but whether this is a story that ends or a story that continues. I've been doing this long enough to have a sense of the difference. This is the second kind. Ending line. I went back to Windsor one final time. It was a morning in November, colder than October, the kind of cold that settles in and means it. I stood near the Henry VII gate and watched the guard at his post, and thought about everything I'd learned over the weeks since the abdication announcement had turned a gray Tuesday into something that would be discussed for a long time. The guard standing there was young, 20-something, upright, composed, trained, standing with the stillness that the institution asks of the people who serve it. I wondered what he saw from where he was standing. I wondered what he had already seen that no one had thought to ask him about. Then I turned and walked back toward the town, past the tourists with their cameras and the shopkeepers going about the morning, and the woman walking a dog who smiled at nothing in particular. And I thought about James Whitmore's words, relayed through a friend who had asked if he was all right on a day when he was not all right. It's like there are 2 sets of rules, and I'm only allowed to follow one of them. There is something, I've come to believe, profoundly important in the act of someone who has spent their entire professional life being still, ceremonially, institutionally, professionally still, finally deciding to move. Not dramatically, not destructively, but with documentation and a solicitor, and the specific, patient kind of courage that doesn't look like courage from the outside, because it doesn't announce itself. It just walks forward, one step at a time, and it doesn't stop.